Welcome to today's discussion where we'll cover everything you need to know about the R1 visa for religious workers. My name is Ebony Anuforo, and I'm an immigration attorney helping individuals and organizations navigate U.S. immigration law. In today's session, we'll not only talk about the eligibility and the application process, but also highlight a critical choice applicants face whether to apply through consular processing or change of status. By the end of this discussion, you'll have a clear roadmap for your journey. Let's dive in. What is the R1 visa? The R1 visa allows religious workers to temporarily live and work in the United States. It's available to ministers, missionaries, and other individuals performing religious duties, provided they meet certain criteria. This visa is valid for an initial period of 30 months, with an option to extend for another 30 months, making the total possible stay 5 years. Eligibility for the R1 visa depends on three main factors. First, you must have been a member of a recognized religious denomination for at least 2 years before applying. Second, your job must involve religious duties, not administrative or secular tasks. And finally, you need to be sponsored by a US based nonprofit religious organization. Both the religious worker and the sponsoring organization must provide detailed documentation. Workers need to show proof of their training and religious background, while the organization must demonstrate its tax exempt status and ability to financially support the worker. The R1 visa process begins with the sponsoring organization, typically a religious organization, filing Form I-129 petition for a non-immigrant worker on behalf of the religious worker. This is a critical step as it establishes the basis for the worker's eligibility to serve in a religious capacity within the United States. Along with the form, the sponsoring organization must include a comprehensive set of documents supporting and proving both their own eligibility and the qualifications of the beneficiary. This includes proof of the organization's tax exempt status under Section 501c3 of the Internal Revenue Code or an equivalent qualification, evidence that the organization is a bona fide religious entity operating in the U.S., a detailed job offer outlining the role, duties, and how they align with the organization's religious mission, and proof of the beneficiary's qualifications for the position, such as their prior experience, training, or education in the religious field. It's important to note that the standard processing time for Form I-129 can take several months due to USCIS backlogs and case complexities. This can be challenging, especially if the religious worker needs to begin their role within a specific time frame. However, the good news is that premium processing is available for R1 visa petitions. For an additional fee, USCIS guarantees expedited processing with a decision rendered within 15 calendar days. This option can significantly speed up the process and is highly recommended if timing is a critical factor. Keep in mind that even with premium processing, accuracy is key. Errors or missing documents can still result in delays caused by requests for evidence or RFEs, which could ultimately negate the time saved. Working closely with an experienced immigration attorney at this stage can ensure the petition is well prepared, comprehensive, and meets the USCIS standards from the onset. An important decision for R1 applicants is whether to apply through consular processing or change of status. Consular processing is required for individuals outside the U.S. or those who prefer to leave and re enter the U.S. after visa stamping. You'll attend an interview at a U.S. consulate, and upon approval, you can enter the U.S. on the R1 visa. Change of status, on the other hand, is an option for those already in the U.S. on a different visa. This allows you to change your status without leaving the country. However, you cannot begin work until USCIS approves the petition. Processing times vary based on the method you choose. Consular processing can be quicker if the embassy has availability, but this depends on local backlogs. Change of status filed directly with USCIS can take several months unless you opt for premium processing, which guarantees a decision in 15 days. If you're currently in the US on a B2 visitor visa, timing is critical. You must file your change of status application before your I-94 expires, and you cannot begin work until your R1 is approved. Engaging in unauthorized work can lead to visa denial or other penalties. Some common challenges in the R1 visa process include incomplete or insufficient documentation, delays caused by requests for evidence, also known as RFEs, and issues related to the sponsoring organization's eligibility, such as their tax exempt status not being properly documented or recognized by the IRS. Incomplete documentation can occur when applicants fail to provide key evidence such as proof of the sponsoring organization's religious purpose, their role within the organization, or their qualifications for the position. Similarly, RFEs are often issued when USCIS needs clarification or additional evidence to verify claims made in the petition. These can result in significant delays and added stress to the process. Another common hurdle is proving the sponsoring organization's tax exempt status under Section 501c3 of the Internal Revenue Code or other equivalent qualifications. If this documentation is missing or inaccurate, it could lead to outright denial of the petition. Furthermore, timing can be a challenge, particularly if the applicant is already in the US on a different visa status and needs to switch to R1 status before their current status expires. Processing delays, especially in standard processing, may complicate this timeline. While premium processing offers faster adjudication, it's crucial to ensure the application is complete and accurate to avoid unnecessary delays or denials. Planning ahead and working with an experienced immigration attorney can help avoid these pitfalls. An attorney can assist in ensuring all documentation is in order, providing thorough responses to RFEs if they arise, and confirming that the sponsoring organization meets all the eligibility requirements. They can also guide applicants through the specific requirements of either consular processing or change of status, depending on their situation. Taking proactive steps early in the process can help reduce stress, minimize delays, and increase the likelihood of a successful outcome. Thank you for joining today's discussion on the R1 visa process. I hope this session has provided you with the clarity and guidance needed to take your next steps confidently. Whether you're applying through consular processing or considering a change of status, remember that the key to a successful application lies in preparation, proper documentation, and timely filing. If you have additional questions or need personalized assistance, feel free to contact us by calling our office or scheduling a call online. We'd love to help you on your immigration journey. Also, don't forget to subscribe to this channel for more educational content on immigration topics and follow us on social media for updates. Once again, thank you for spending your time with us today. I wish you all the best in your journey and look forward to assisting you soon. Have a great day.